Well, welcome back to our next episode of Garris Horn Insights. Today I'm here with managing partner Rich Horn to have a conversation about the current status of the CFPB and what's going on. And of course, what's interesting here with Rich is not only is Rich, of course, a regulatory attorney extraordinaire and knows a great deal and everything about, of course, mortgage regulation. But he actually, of course, spent time and worked at the CFPB and is very close to the people there, I'm sure. So his insights are going to be unique to maybe what we're hearing out there about what's going on with the CFPB. So thank you, Rich, for being on the podcast. And so I'll just simply kick it off with, the CFPB. What are your thoughts?
Yeah, well, thanks for arranging for this. It's going to be an interesting discussion and hopefully helpful to our listeners out there to think about how to navigate these drastic shifts in what's going to happen to the Bureau. If you recall, back after inauguration, Chopra was still there. I guess he was showing up each day hoping that his key card still worked. And it did for a while, and we were all wondering, hey, what's going on here? He's not been fired yet. And there was a lot of discussion about why that might be. But then, lo and behold, out of the blue, without prior warning, there was news that Trump had finally fired Chopra and not designated Treasury Secretary Besson, who had just been confirmed as Treasury Secretary. He designated him as acting director of the CFPB. So it looked like what was going on is the Trump administration was waiting for somebody that they trusted to be confirmed by the Senate to put in place as acting director. And then a couple of days later, I think it was his first workday as acting director, he issued a pause to the staff of the CFPB, basically saying, hey, pause your work in litigation, enforcement, new rules, and other public communications, and then also start rulemaking to suspend the effective dates of rules that haven't taken effect yet. And a lot of people, again, in the industry and outside counsels and in-house counsels and anyone who was writing about it just seemed to agree that this was kind of this plain vanilla pause. It was worded as having the goal of promoting consistency with the goals of the administration and not as a permanent stop work order. But so I think a lot of people thought, oh, well, Treasury Secretary Besson's going to keep running the Bureau, just taking a pause to review what the Bureau was working on. But then a couple of days later, we have yet another acting director designated by the Trump administration, newly confirmed OMB director, Russell Vogt. He was designated acting director of the CFPB on February 7th, and he extended the pause to include also supervision. So, that's one of the main functions of the Bureau is to examine non-depository and large depository institutions. And before that wasn't subject to Besson's pause, but Acting Director Vogt extended that pause to include that important function of the Bureau, and then also issued I don't know what you call them these days, tweets or posts or what they're called, but on formerly Twitter, now X, he posted that he was going to request $0 from the Federal Reserve for the CFPB's funding. And I think we've talked before about the CFPB's funding structure on our blog, on our law firm's blog, and on some prior podcasts as well. So I won't get into that, but basically the CFPB requests their funding from the Federal Reserve, and there's a large cap. And instead of actually requesting some funding, Acting Director Russell Vogt requested $0 and then posted on X that the spigot is now being turned off, and has called the CFPB a weaponized agency, described it very negatively as well. So it looked like what was going to be this kind of plain vanilla pause was becoming something very different. And on that same day, Elon Musk, head of Doge, also tweeted or posted CFPB RIP. So putting that all together, we went from wondering why Chopra wasn't being fired on January 30th and January 31st until he was fired, to February 7th, like basically a week later, to the CFPB being killed. And so it's kind of like a whiplash, right, for the industry. And so I think there is a lot of confusion in the industry of what to make of this. And there's been a lot of stuff that's happened since. I can talk about some of it, but basically Doge went into CFPB to go through all of their data. Acting Director Vogt started firing a bunch of staff. He fired the probationary staff. So when people start working in government, they're on what's called a probationary status, where they can be fired if they're not up, up to the standards of the agency. And so it's usually a very individual thing. If you're just not, working out, you're not doing well enough, they can fire you. But this was a mass firing of probationary staff. I think it was like 100 people, including maybe a large group of enforcement attorneys as well. And then there was a White House statement, and even Trump before reporters really railing on the CFPB. The White House statement said that CFPB is another woke, weaponized arm of the bureaucracy that leverages its power against certain industries and individuals disfavored by so-called elites. That's you don't have to wonder what they're thinking about the bureau with that language.
Yeah. I think the intention is a little bit clear. So yes, absolutely.
Right. And then February 10th, Trump was in front of reporters and basically said, yeah, he wants to get rid of the CFPB. He said it's a very important thing to get rid of. And so it really does look like the Trump administration's focus has been to get rid of the CFPB. But then the National Treasury Employees Union, I think I got that right, what the acronym stands for, NTEU, they represent the employees of a number of federal financial regulatory agencies, including CFPB. And so they sued on behalf of the CFPB members and challenged two things that the CFPB was doing. One is the Doge access, and then the other was Acting Director Vogt's stop work order. And that case is before Judge Amy Berman Jackson. You can just look it up yourself. She's an Obama appointee, and she's had some other rulings that were not favorable to the Trump administration. And so it does look like she, if you following that case, and we have, but it'd be probably a couple hour podcast if we got into all of the nitty gritty of the case. But I'll just mention she's had decisions in the past that were not favorable to the Trump administration. So it does look like there's a chance that she rules for the NTEU, and there are other plaintiffs that have joined the case as well. That case seems to have kind of brushed the current acting leadership of the CFPB and maybe the Trump administration back as well, because there's been back and forth in the case where the plaintiffs, the NTEU and the other plaintiffs, are saying, look, this stop work order is illegal, it violates separation powers, the Administrative Procedure Act, and they're trying to shut down the agency. And then the Trump administration has filings basically saying, we're not trying to kill the Bureau. The Bureau is going to be continuing on. And so it seems like perhaps at least the rhetoric from the Trump administration has been affected by this case. There has been reporting that one of the ultimate goals of the Trump administration is to move the CFPB under one of the other agencies in the executive department. So it could be the Treasury, it could be specifically under the OCC, and so that's what the reporting looks like. It'll be like their plan was to move it under the OCC. There have been statements from people close to the administration saying that one idea is also to put it under the Justice Department as well. So who knows what could happen there if the case actually is decided in the administration's favor. But right now, that case looks like it's brushed the administration back from killing the bureau as look like what it was the original plan. It's also interesting to note that the current acting director vote this I don't know what you call it, a think tank, I guess, is very conservative leaning think tank that he founded called Center for Renewing America on February 10th also put out a what they call the primer on the CFPB, saying the CFPB should be shut down. They cited some of the same problems with the CFPB that were cited by the Trump administration, um, and some of the proposed reforms look like what the acting director vote was trying to do. Basically, not fund the bureau at all, not conduct any rulemaking, fire the staff, but if you read further into that primer, it looks like the at least until the CFPB is um, abolished through legislation, that they're they're proposing that the CFPB be continued to operate, but just to focus on its statutory objectives
Well,
until it could be somehow affected by
let me
legislation.
let me
So
ask a let me ask a question, if I may, or at least kind of bring up a point, because you kind of touch on both of them. It's kind of interesting, and that is, in one fashion, people would say, sure, if we have dual agencies, maybe we can save money. We combine them, and that seemed to be somewhat the message from the administration. Separately, there's either acts and some, it sounds like, actual statements regarding the need for the CFPB or its overreach or whatever it might be. Right. In other words, it's more the intent of the CFPB that they're opposed to versus the fiscal. So, do you agree with that? In other words, we're hearing a lot initially. Well, there's a lot of agencies. Let's just bring it under the other one. We're saying it's just a cost cutting measure. But it seems like there's an undertone, at a minimum, I'm being polite, that it's really more political than that. Am I on the right track?
yeah, we were hearing a lot about how the CFPB might be killed entirely. Well, then there would have to be legislation to deal with
Correct.
which agencies get the authority over the underlying statutes, right? TILA, RESPA, ECOA, FICRA. That authority is going to have to go somewhere. So at least to some extent, something would have to be shifted to another agency. Now, if they instead just right now the CFPB has a bureau inside the Federal Reserve. Let's say they decided, well, let's just move all of the functions officially into the Federal Reserve, or move them officially into FDIC or OCC. That can be done as well, and as long as those statutory functions still exist, one could argue that there shouldn't be really an impact on the level of consumer protection, supervision, or enforcement, because the government still has that authority. It can still enforce in the same way. But I think what would likely happen is at the same time there would be limits added to the authorities that are being transferred. Right. So right now, the CFPB has broad. I'm just going to pick on rulemaking for a second, because
For
as you
sure.
know, I was in the Office of Regulation, so I know the rulemaking function very well. Um, in TILA and RESPA and ECOA, there are such broad grants of discretionary authority that basically have been interpreted by the courts. And I know we're going to get to some of the cases, like the Townstone case that I was on later on in the podcast, but there have been decisions by courts, including in the Townstone case in the Seventh Circuit, that basically say under these broad grants of rulemaking authority, the CFPB can basically do whatever they want, even regulate outside the statutory boundaries that are set forth in the actual statutory language. And so that broad rulemaking authority, discretionary rulemaking authority, has been used by the CFPB in the past to really go out and make entirely new law. And those new rules, which are essentially new law, they don't get challenged unless there's a real will by the industry or an industry trade association to challenge it. And it started to get challenged more. The CFPB did in the past few years, uh, but that's was kind of a new thing. And so for many years before that, the CFPB had been issuing rules that, at least in part or maybe in whole, were based on this discretionary rulemaking authority that went unchallenged, and so became basically the law of the land for the industry. And I get it; it's tough to challenge your regulator, right? If you sue your regulator, you have to be worried about, one, well, the cost of the litigation, that's important, but also any blowback, right, from suing your regulator that you actually might need to have positive relations with, in exams, or if you're requesting guidance. And so it's a very difficult proposition. I think that hopefully, actually, I hope one of the things that Congress and the administration focus on are these broad grants of rulemaking authority, because they have been abused by the CFPB in the past, and have gone unchallenged. But I think that if there is legislation that moves the CFPB's functions, and I think that things like that, to put more guardrails around the CFPB's um, authorities, would be also added to law. The law would be amended to do that. So, uh,
But I can see then that this is part of it. Again, we don't know the intentions absolutely, but sure, cost savings or making it more efficient. And like you said, maybe it might say statutory remedies. There are amendments to move it elsewhere, keep it inside maybe the Fed. So there are some things about just efficiency, if you will, but there is a theme that just seems undeniable, that the mission, or how the mission was executed by the CFPB, as we know, it was maybe outside their reach, and they're taking an issue with that as well. So
right,
even if,
100%. Yes.
yeah, got it. Okay, yeah,
Yes.
that's. I
Sorry,
mean,
I
look,
didn't touch
yeah,
upon that. Yes.
yeah. No, go
Let,
ahead.
let,
Sorry.
let me back up real quick, because I want to go back to the whiplash we've had with what's going to happen to the bureau. After the NTU lawsuit, even the administration, like I said before, had been, you know, looked like it was trying to kill the bureau. But then they go and nominate a permanent director, former FDIC board member Jonathan McKernan, who does, if you look at his past at the FDIC, at least, looks like he's somebody who views uh, federal financial regulation in a very reasonable way. He definitely has a lot of statements that say we have to focus on our statutory authorities, which is a good thing, something that the Bureau hasn't done so much in the past, which we'll talk about soon. But at the same time, Jonathan McKernan doesn't look like he's somebody who's anti-regulation and who also wants to kill the Bureau. At the nomination for McKernan at the Senate Banking Committee, he actually had some, what I thought were positive statements. It looks like he is focused on the Bureau continuing to operate according to its statutory mandate. So he talked about how the North Star is to follow the law. If the CFPB has, I'm paraphrasing here, but the CFPB has statutory mandates. That's how he'll run the agency, to follow the statutory mandates. And so that was viewed positively. And so it almost looks like, either the NTU lawsuit has moved the administration back from trying to de facto kill the Bureau, or it's just kind of like a schizophrenia part of the administration.
I think, yeah, because I listened to, of course, I listened to the hearing from top to bottom, and it was very interesting. And my sense was, and you tell me what you think. My sense was, they're getting more realistic about what they can and cannot do, based on. So it's one thing to be, in the media and saying this is where, RIP, and another one to say, well, look, this is actually the power that we do and don't have in this context. And I think with McKernan was a great example of, look, we know how this, we understand the boundaries a little bit better now, or you probably always did. And even then, I think he ducked a lot of things in saying like, "Look, I'm not getting into the politics of it. I have an agency to administer whatever that agency is, and I will administer with all my heart and desire and within the legal authority." So I think that's kind of how he responded and kept the focus on that, and I think that was kind of telling. So I agree. It's interesting.
Yeah, it could be also just a play, trying to put all your pieces on the board in the right places, right? So it could be get acting director vote to kill what he can at the bureau. It's more of like a retroactive approach, right? Fire all the people that have already been hired. Um, you know, stop what the bureau's been working on. New investigations. Just actually, and we didn't even get to this yet. They dismissed a whole bunch of cases that they had already brought, including some important ones for the mortgage industry, like the Rocket Homes RESPA case, the Vanderbilt ATRQM case. And so there are some important cases that were dismissed. And then McKernan's kind of a prospective play, right? That is going to focus on, I think he described it this way in his opening statement as well, is to right size the bureau, basically make a
Correct.
leaner bureau. So it could be just putting your pieces on the board to affect change in all the ways you possibly can. And so it might not be really schizophrenic; it just might be a good strategic move.
Yeah.
But back to, I think, like you were mentioning before, which is a good point. How did the bureau get in this position? And I think it's because during the Cordray and even actually during the Kraninger years as well, and then of course during the Chopra years as well, that the bureau has been an incredibly aggressive agency in a lot of ways, and particularly in its enforcement function, taking cases with novel, very aggressive legal theories. And if you, at our firm, we've had a number of enforcement matters with the bureau, and they are very aggressive in those matters, and to the point where they're going after individuals in the cases that really it's unnecessary, where it's unnecessary to do so. And it's hard to watch as somebody who's worked there, who believes in reasonable regulation and agencies trying to follow the law and staying within their statutory boundaries, to see to see it, and especially when you're defending people against the bureau, like in the couple cases that I think we've talked about in the past, that have been really surprising. One is the Townstone case, which, as you know, I represented Townstone in the investigation and throughout the litigation with the CFPB. There, in that case, they had redlining claims against Townstone that were totally unfounded. We gave them evidence that their theory was incorrect. They were alleging that a couple statements by Townstone on an AM talk radio show were discouraging to African American residents on the South Side of Chicago. It was like, basically 5 quotes, about 5 minutes out of hundreds of hours of broadcasting. That in and of itself makes it a crazy case. But when you add into the fact that I actually decided to consumer test those statements with actual African American residents in the South Side of Chicago, using a consumer testing firm that the CFPB had used when the CFPB was conducting the TRID rule. So I knew that consumer testing firm did really good work. And so we used that firm to do the consumer testing, and they created a report on the statements, and they found that actually African American residents on the South Side of Chicago liked the statements. They were asking for Townstone's contact information because they said, "Hey, this guy knows my neighborhood. He can help me actually find a place to live. He's funny. He knows. He knows our neighborhood really well." And so the CFPB in the Beltway bubble was saying that these statements were discouraging, but actual data showed that the statements were encouraging. That it actually made people want to call Townstone to get a loan, but the bureau wouldn't listen to the data. They had their legal theory. They probably wanted a press release that looked great. They went, go at the first federal redlining case against a non-bank mortgage company and look at these horrible statements because that's the way the bureau was operating. They were operating on press releases, not on actual justice and what was true and correct and right. And then to make matters worse, they actually added the owner of Townstone to the case personally, just to turn up the heat. I mean, so they're really out there trying to destroy people's lives just for press releases, and it was just really sickening to watch. I've seen it again in another case dealing with licensing, where they allege that a company didn't license some of its staff correctly under state law, and they just didn't like the owners of the company. And so to turn up the heat, what did they do? They added the owners to the case personally, threatening to go after them for millions and millions and millions of dollars in penalties personally, basically trying to destroy their lives again because they just didn't like them. They wanted a press release over licensing. I mean, it's just ridiculous stuff. And then I had another case where, and this is the Counsel case. Actually, is what's funny is that I should mention the Trump administration. And this go around, they're citing as one of the problems with the CFPB the Counsel case. That the Counsel case is an example of the CFPB using its authority to go after what they call disfavored individuals, um, and they mentioned the Townsend case specifically. What they don't mention is that actually the case was filed by Director Kraninger, who was a director during the first Trump administration.
Yeah, exactly.
So these problems are just, I think, they were structural inside the agency. Even a Republican Trump appointed director was responsible for some of these horrible cases. Another one that former Director Kraninger was responsible for was this case where the CFPB was going after a client of mine, basically trying to expand the definition of credit under ECOA and FICRA to include something that was completely not credit. I won't get into the details because will get technical, but basically, this case we're trying to expand the CFPB's jurisdiction to go into industries you would never ever think of the CFPB having jurisdiction over, and the client hadn't even ever heard of the CFPB before. It was completely news to them that there was even that they would even ever be considered credit because they weren't providing credit at all, but the CFPB was just trying to expand its jurisdiction, and it's hard to watch as somebody who's like myself, a proponent of reasonable regulation. It's really I think the CFPB is unfortunately given itself a black eye because what they weren't doing at the same time is going after actual bad actors in the marketplace, right? They're using all their resources to go after these novel, aggressive legal theories and going after trying to destroy people's lives because they made a couple statements on the radio they didn't like. But they're not going after. There's so much low hanging fruit out there. People engaged, especially in mortgage, but in other industries as well, engaged in deceptive marketing and just blatant violations of law that the CFPB is not going after, hadn't been going after. And I think when we talk about what should happen at the CFPB, I think it needs to be structurally changed so that these crazy cases can't get taken up.
So let me, because you bring up two things I think, and one of them you kind of lightly, but I think it's critical. First of all, and for those who listen, right, we as attorneys are always passionate about our cases, our clients, and so of course we're going to sound, we might sound, leaning towards one side or the other in these cases because we defend our clients. But in these cases, Rich, you're talking about on the face of it, it didn't make sense. This is not us just saying our clients were ramrodded or there was something went wrong. It was actually, this doesn't even make sense. You can't even operate in an environment where you're, I'm going to put it this way, making up the law. And that's really what was happening. And that, again, that's on the face of it. You can check that out.
100%.
Yeah, exactly. So I think that's critical. I want to remind people like this is not just this passionate advocacy for our clients. This has to do with the fact that no, these are functionally flawed on the face, and you can just read it and you raise your eyebrow. So to be clear, these are extraordinary situations. Secondly, and I think this is the kind of the thing you structured to hit kind of quietly, but I think it's key and maybe explains a couple things that in the first Trump administration, it kind of told you that some of these actions that came out maybe was more a reflection of the structure. It was just so built into the DNA that an administration who was just administering it maybe couldn't make change, and maybe it explains, and maybe to some degree overdoing it, in my opinion. But the shock and awe approach to doing this time, to say we really have to change how the structure works and go a little bit deeper. Maybe that's the motivation, and that's just my opinion, my observation. I could be wrong, but
I think you're right. I think it's the single director structure. It's really
yeah,
unfortunate that the CV was structured that way, because what it means is um, the entire industry is subject to the whims of one person, or the lack of consumer finance knowledge of one person. Right.
correct.
That's one positive thing about the new nominee for permanent director, McKernan, is that he does come with actual financial regulatory experience, including consumer finance experience. So that's a positive. But when you have a single director structure, it's that person's way or the highway, and there's no real discussion within the agency to tamper down those extreme viewpoints, or deal with an issue of, again, lack of expertise or knowledge by that director. So I think that's if if the Congress does anything to the bureau, I think putting it under a commission or a board has to be number one on the list, because that will solve, I think, a lot of the problems. Now, we can't solve every problem, right? Because
Correct.
you're still subject to a vote of that board or commission, and the agency can certainly vote the wrong way. And it could have a majority that still acts like a single director, because they're basically voting as one block, and they're all in agreement. They're all super aggressive. That could be an issue, but I think it does cause a, a, a does cause a place for discussion, right? At
Correct.
board meetings or commission meetings, where opposing viewpoints can be brought to the table at the same level, right? So, staff, when in a single director structure, can bring opposing viewpoints to the single director, but those aren't going to have the same weight as when you have other board members or commissioners bringing those opposing viewpoints at the same level as the chair of the board or commission.
Well, I think, and typically with the commissions are often structured as it's designed for balance. So it's not just one type of thinking. The way it's designed is often to give a balanced approach in administering the agency. So certainly, first you have to get the right structure, but it's certainly, if it's a single person, that's going to call a lot of things into question and maybe overpower them. And I think that's what we had been seeing all through. I think, in my opinion, the administration of the CFPB, and particularly more in the enforcement. Not those who wrote regulations did it brilliantly. Don't worry, Rich. But no, but I get that, and I actually want to talk about that in a second, about the good administration of the CFPB, what it does, and consumer protection, and we need regulations. I want to shift to that, but yeah, I think it was more the enforcements, and I will tell you, and you've done this, Rich, as well, as when you're trying to advocate for your client, just doing things internally. Hey, we have an idea, we want to do this. What do you think? And the answer is, well, we think it's a great idea. We can't tell you in these light to medium gray areas how it might be perceived by the CFPB, and that creates a chilling effect when you really can't read where it's going, or for anything you read is going to be negative because you just don't know. The way the CFPB had acted before, it was unpredictable. So I think that was one of the challenges, cost that we have. We mean to do well. I submit, pretty much, clients, lenders, they mean to do well. It's just we have to understand what the rules are, and then we'll deploy them accordingly, or employ our solutions accordingly. And then again, I think there's a lot of healthy respect for law regulation, particularly for consumer protection. I mean, again, I don't know how many, I don't know on the list of the priorities when they did these enforcement actions where actual consumer protection was the priority versus a headline. And I don't want to be provocative, too much opinion here, but you get the idea. So I don't know about that. I think at the end of the day, it's a matter of putting these rules in place for consumer protection and to protect consumers. And you start with that. You don't end with it. You start with what kind of risk are we hedging here, and then take it from there and not have an agenda beyond that scope, in my opinion. But so, Rich, we know regulation has its place. We know, and certainly you've been very instrumental in that. So we know that maybe there are some enforcements and interpretations we expect that's going to change, and yet I submit that we don't want baby bathwater issue, right? We still need good administration of laws and just guidance. We like to have the guardrails. We don't want to cross them. We just want to know where they are. So I submit that we have opportunity here still to do some regulation. What are your thoughts on that?
Absolutely. There is a lot of positive that the Bureau can do and has done, right? I'm not, I am biased, I guess, I should say. I'll be honest, but I'll give an example: the trade rule, right?
Yeah,
That
I heard of it. Hey, you know what? I know the guy who wrote it.
right. He's a really nice guy, handsome.
He's a nice guy. He's a great guy. Brilliant guy.
And so that rule is an example of, I think, really good rulemaking, right? Congress mandated integrated disclosures, and so what did we do at the Bureau? I say we, because as you know, I led the rule and I used to work there. We made sure that consumers could understand the disclosures. A lot of times in the past, when agencies would have a mandate to create a disclosure, they just plopped all of the statutory language on a form and said, "This is the disclosure. There you go, industry." And it was never useful to consumers. And so if it's not useful to a consumer, it's useless, basically, because all it is just money spent by the industry, and you have no benefit, right? So we made sure that consumers could understand the forms. We actually also tested it with industry to make sure that they thought the forms would be useful in their expertise. And so a lot of work was put into that. I led 17 rounds of qualitative consumer testing. I led the CFPB's first quantitative consumer test with about 1,000 consumers, comparing the old forms to the new forms. And so these forms came out. I think industry was maybe critical of it at first because it was new, but after a couple of years, I think there were a lot of studies that were coming out, even some internal studies from industry that I'd seen that said, hey, consumers are actually using the forms and understanding them. Now, some people might still not like them because it's a government form. It's not like, it's not going to be the greatest thing since sliced bread, right? It's not going to change your life for the better as an industry, somebody in the industry. But it's something that has improved consumer understanding of their mortgage transactions, and so and it's also something that, if you think about, the industry would never have gotten together and done on its own. There's a place for financial regulation, especially trying to make opaque transactions understandable and clear to the consumer. That's something that it's highly unlikely that the industry would get together and self regulate and create a really usable, consumer-friendly form on their own. It's just not going to happen. So that's a place where financial regulation can have a real impact. Now, some people might question how useful of a consumer protection tool disclosure is, and there's a lot of research on that about potential, negative impacts from too many disclosures, because it can result in information overload. And so there's definitely questions about how useful disclosures are. But I think that's an example of where regulation can actually be helpful. And there's other regulations as well that I could cite too, but we're on a podcast, so I don't want to have people listening to this for hours. So I'll spare you all of the long list of the other rules. But there's also rules where the CFPB has gone off the rails, and like I was alluding to before, just not tried to stay within their statutory limits, and they went off and created new law. One example is in the CFPB's mortgage servicing rule, all of the loss mitigation provisions that that actually was not mandated by statute at all. The CFPB only used its discretionary rulemaking authority in RESPA for that, which says, hey, CFPB can promulgate rules that further the purpose of RESPA. Well, I mean, yes, CFPB can issue rules to further the purpose of RESPA, but if RESPA doesn't mention anywhere the rules that you're actually promulgating, is that really furthering the purpose of RESPA? And there's a big question mark about that. And should the CFPB have been able to go and do that? I think that's an example of where the CFPB has given itself a black eye. Now, that rule has not, at least to my knowledge, not been challenged yet by the industry. You know, if you think back to when those rules came out, it was right after the Great Recession, um, and maybe the policies in those rules make sense, and there's a huge interplay between federal and state law and servicing, and so it's a very complex area. Now, and it's still an example, though, of how the CFPB has abused its authorities, in my opinion. And
Correct.
so
Correct.
I'm a proponent of good regulation and agencies staying within their statutory authorities. And if that can still happen at the Bureau, then I think Congress should let the Bureau exist. Um,
Yeah.
there's also new authorities that were given to the Bureau that weren't that didn't exist before Dodd-Frank, right? The federal supervisory authority over certain non-banks, like mortgage, and so that's something that Congress would have to figure out where what to do with that if Congress decided to abolish the Bureau or move its authorities into another agency. That's Those are questions that make it more difficult, than just saying delete CFPB, as Elon Musk had tweeted in the past, or let's abolish the CFPB, because there are actually, um, you know, there are actually some unique authorities that the Bureau has that deserve some thought about whether those authorities should continue in a post amendment world. And the last thing I should mention about the current state of the CFPB's quote unquote shutdown is that the CFPB has certain statutory mandates in the Dodd-Frank Act. So the Dodd-Frank Act says, CFPB, you have to supervise non-banks. The Dodd-Frank Act says, CFPB, you have to have certain offices, like the Consumer Response Office that takes in consumer complaints. There's mandates to monitor markets for risks, to publish certain reports, and so right now, as the CFPB is under this stop work order, it's really not conducting these mandatory statutory functions, and so that's something that I also, although I disagree with a lot of what the CFPB has done in the past, as we've talked about, I completely disagree with the current approach of, or what I should say, what appears to be the current approach. We'll see how it shakes out in the NTEU lawsuit, and I think there's actually an evidentiary hearing today to see, so the court can see what's actually being done at the Bureau, and so we'll have to see where that court case falls, on the side of if the CFPB is actually conducting these statutory mandates or not. But what appears to be the case, at least from a lot of the statements out there in the press, is that the CFPB is not conducting its statutory functions, and that's unfortunate. That's something I'm not a proponent of, because I think the
Right.
CFPB does have to follow the law. Just has to follow the law to actually conduct its statutory mandates, and it also has to follow the law to stay within its statutory authority.
And so with all of that, right? So, and thank you, by the way, for navigating all of that, everything from our how we got to our current situation, as a matter of technicality, as it were, how we can see, or others can see, maybe where the CFPB stepped out of bounds, and good examples of that, and yet at the same time, reasons why CFPB does good, for lack of a better phrase. You know, what do you think we're going to see in the near future, and particularly, having again the special insight you have, and extraordinary experience in this exact space? What's the best advice we give people insofar as how to navigate now and in the coming months?
Great question. I think for the industry, it's keep the foot on the gas with respect to compliance. Don't act like it's game on for doing whatever you want. You don't have to worry about enforcement anymore, because that's not the case. You still have one, the underlying statutes that apply. So TILA, RESPA, as I mentioned before, ECOA. Those have private rights of action. So you could have plaintiffs, basically borrowers suing you, or consumer advocacy groups suing you based on any violations. You could have state regulatory agencies that still enforce those laws, because a lot of states have what I call piggyback laws that say, hey, violation of federal law is a violation of our state law, and so they can
Mhm.
enforce the federal law as well. They could find violations and enforce against you, and so, or state AGs as well. So I don't think this shouldn't be read as, hey, let's all go out and party on the street. There's no more
Right.
no more adults around. I think you've got to keep your compliance function robust, because also some states are probably going to become more aggressive. I mean, they see what's going on with the CFPB, and they'll believe they need to pick up the slack, fill that void, and so you could face harder state exams as well. So I think that's an important takeaway for our listeners. The other is to just keep on watching what's happening. It's very, I think, just very intellectually interesting. The discussion about what should happen to the CFPB, also just following what could happen, is just fascinating to watch the court case and to see what people are writing. So it's interesting to watch as well.
Well, thank you for your input and your observations. Like I said, I think you're in a unique position to share this information, and greatly appreciate that. Any final thoughts and final advice you might want to give the rest of us?
I think it's to stay focused on compliance, because the state agencies are probably going to try and fill that void if they perceive that the CFPB is not supervising and enforcing as it had been before. They'll try and pick up that slack. So
Yeah.
um, you know, try and stay focused in spite of probably a lot of noise out there saying, hey, we can do whatever we want now. The CFPB is done. That's not the case, and you have other things to worry about than
Right. I completely agree. I think, it's not as if we, and again, having been in house many years myself, it's not as if lenders are sitting there and saying, "Oh, good, now we can violate Section 8 of RESPA." I mean, there might be some more ideas of innovation that you might see coming out, but still, yes, and particularly for the consumer, particularly for the compliance professionals that support those groups, whether in house or outside. We're stewards of the laws still, so we might be even a little more active to remind them of what the boundaries are, and so it's still incumbent upon us to remind again the industry out there to, like you said, keep the foot on the gas, right? And but the guardrails are still there. Just you got to find out who's going to be. Some of it you have to self-administer, and some of it, there might be other people telling what those guardrails look like. So thank you, Rich, for your time, your insight. And
I totally am open to any comments you want to discuss. Please give me a call, shoot me an email. Happy to talk about this topic or any other topic anytime.
thank you, Rich. Greatly appreciate that. Again, thank you, everyone, for listening to Garris Horn Insights, and we hope to see you next time in another episode of Garris Horn Insights. Thank you.